All right, good day, everyone. My name is Stephen Berenson, and I'm an administrative law judge with the California Department of Social Services. Before assuming my current position, my practice consisted of legal ethics counseling, defending lawyers in legal malpractice and state bar discipline cases, and representing judges in judicial conduct proceedings. So, the subject matter of today's presentation is very familiar today. I'm calling this presentation "The Great Lawyer Knows the Judge, the Law, Ethics, and Effectiveness of Lawyers' Interactions with Judges." I got the title from this mug, which you may have seen a version of online or on someone's desk. I got a version of this for a friend of mine a number of years back when they got appointed to the city court in White Plains, New York, our hometown. And whereas I meant it as a joke, and of course the mug is meant as a joke as well, like all good jokes, there's more than a little bit of truth in it. And so I want to, offer some tips on how you as a lawyer can get to know the judge and therefore become a great lawyer, all the while staying within the confines and boundaries of law and ethical principles. And so, just to reiterate, of course, here I am not going to be discussing anything illegal or inappropriate, untoward, not talking about bribes, extortion, or anything of that type. Obviously, we all know there are rare instances of that type of conduct that occurs, but this presentation, of course, is directed at the 99.999% of lawyers who want to be successful, want to get on the right side of the judge, but obviously want to do so within the confines of legal and ethical boundaries. So I'm going to be dividing today's presentation up into a focus on lawyers' interactions with judges both outside the courtroom and inside the courtroom. In terms of lawyers' interactions with judges outside the courtroom, I'm going to focus on MCLE programs, mandatory continuing legal education, conferences and bar functions, ex parte contacts, contacts on social media, gifts and hospitality, and judicial elections. In terms of lawyers' interactions with judges inside the courtroom, I'm going to focus on contempt of court, maintaining client confidences, and I'll close today with a few brief advocacy tips. I'll begin with a discussion of MCLE programs, conferences, and bar functions. As you all know, judges face many restrictions on what they can and can't do, both on and off the bench. One of the primary sources of these restrictions are codes of judicial ethics or judicial conduct that affect judges in all of the 50 states and at the federal level as well. I'm going to be making reference to a number of provisions of judicial conduct regulation throughout the course of this presentation. And when I do so, for the most part, I'm going to be focusing on the American Bar Association's Model Code of Judicial Conduct. And I think, as most of you know, like most model codes, the ABA Model Code of Judicial Conduct, or CJC, in and of itself has no binding effect on judges. However, all 50 states have adopted some version of the ABA Model Code as its own set of binding authority on judicial conduct. And just because I know we have participants from across the country, as kind of a common denominator, I'll refer to the ABA model code. Similarly, in terms of lawyers' ethics, I will also be making reference throughout this presentation to the ABA model rules of professional conduct, of course, the model legal ethics code for lawyers promulgated or offered up by the ABA. Again, the model code, as most of you know, has no binding effect in and of itself, but all 50 states, my state of California being the last holdout, has now finally adopted a version of the ABA's model rules. And so, again, I'll be referring to the model rules as sort of a common denominator. But of course, you all know that you need to consult the specific version of the ethics rules that are in effect in your jurisdiction uh, before relying on a particular rule or provision that's referred to here.